Okay, I think we are ready to go. So, hi everyone. Welcome to Founder Fundamentals, hosted by LaunchU and the Markham Small Business Center. My name is Diana Senwasain, and I am the Marketing and Events Coordinator for LaunchU, which is the entrepreneurship unit at York University. So I can't believe we're already now past the halfway point. So this is now the 7th event in the series. And I know that so many of you have been here from the very beginning with us. So I'd really like to thank you all for joining us from the start. And for those of you who are new, and this is your first time joining us for an event in this series, if you can please type your name in the chat box so we can all give you a warm welcome, that would be great. Now, I do want to let you know that York University has so many programs and events to support entrepreneurs that are completely free and open to anyone worldwide. And if you're looking to start your journey as an entrepreneur or need support to help take your venture to the next level, LaunchU offers free programs, services, and events to support not only students, but alumni and external community members as well. I do want to tell you about a really exciting event that we have coming up next week, actually, and that is our Entrepreneurial Alumni Speaker Series at Home event. So this event really showcases York's top alumni entrepreneurs. And we have 3 events planned for this year. We've actually already done the first event featuring Michael Prosserman 2 weeks ago, or sorry, no, a week ago last week. And we actually have our next event planned for next week featuring Rand Gohl, who is the founder of Fresh City Farms. So if you're interested in joining that event, please do register on our website, launchu.ca/events. And again, that it's free and it's open to anyone. And this event will be taking place at 12 p.m. Now, in terms of this actual series, I do want to let you know that it actually has become really a community staple, and it's designed to help aspiring entrepreneurs build their skills to launch their startup. Now, most of you know that this is actually the first time that LaunchU is hosting the event. So we're really excited to introduce it to you all. And now, especially being virtual, we've expanded and we're able to offer it to anyone worldwide. So I always ask this question, but I'm going to keep asking it each and every session because I'm always interested to find out where you all are joining us from today. So if you can type your location in the chat box and let us know where you're all joining us. I see Trinidad, Hawaii, Toronto, Mississauga, Philadelphia, Nunavut, wow, Chicago, Brampton, Woodbridge, Tacoma, Caledon. Oh my gosh, so many places. Richmond, Unionville, New York, Montreal. Thank you all for joining us today. And we really do want to give you all a nice warm welcome. So as you know, there are 11 events total in this workshop series. And if you do attend at least 9 events in this series, you will get an Innovation York Certificate of Completion. And that certificate will be issued at the end of the last event, which is happening in December. So Zoom does track your attendance, so no need for you to do anything from there. We can sort of see when you sign on and sign off. And we will be issuing certificates to those that stay at least an hour for each session. Now, this series could not be possible with so many people helping us behind the scenes. And I do want to give a nice warm welcome and thank you to David Kwok, who is the Associate Director of Entrepreneurship at Innovation York at York University. And David has worked really hard to source all of the speakers that we do have in the series, as well as the different topics that we always introduce. So I do want to give him a warm welcome. He will be in the chat to answer any questions that you may have throughout the session. I also do want to thank our partners, the Markham Small Business Center, for again providing their support in the series. And I actually do want to welcome Tiffany Mack on screen with me to share a few words about the Small Business Center.
Great. Thank you, Diana. I hope everyone can hear me properly. My name is Tiffany Mack. I am a small business consultant from the city of Markham. I'm here to represent Markham Small Business Center today. So a thank you to Diana, a big thank you to David for all of their hard work to continue to organize these wonderful founder fundamental events. See a lot of familiar names, so I'm glad that a lot of you have been coming back to these sessions. I'm glad that you're finding it useful. The City of Markham truly values its partnership with university, and we've been conducting or producing these type of community events on a regular basis for the past few years now. And for some of you who might be local to Toronto, you might be familiar with the York University campus, and you also might be aware of news that there is a new campus being built in Markham. So a new York University campus in Markham. So very exciting for all of our residents and all the small business owners that are in the area. So thank you again for having us here. We are thrilled to partner with York University once again. I'm going to include my email and website information in the chat box. You can take a look and see what the City of Markham Small Business Center is doing for its entrepreneurs. We are consistently running events like this, so you can check out our events calendar. Take a look and see what sort of funding might be available if you are a Markham business owner. And if you have any general questions about, how do I start my business? What regulations do I need to be aware of? Those type of things, you can always reach out to us as well. If we don't have an answer for you, we'll certainly find someone who does. So thank you again for having us here today. City of Markham and the Markham Small Business Center is really happy to be a partner with York University once again. So thanks everyone, and nice to meet you, Graham. We're excited to hear what you have to say today.
Thank you so much, Tiffany. So yes, Tiffany will be in the chat to answer any questions that you may have. So you can type in your questions using the chat function that we have on Zoom. Just for some housekeeping, if you can please keep your mics muted at all times. If you do have a question, you can unmute your mic and ask at any time during the presentation. You can also type it in the chat box, or you can use the raise hand function that's in Zoom. The format of the presentation will be pretty casual, so please feel free to type in your questions at any time or raise your hand at any time if you do have a question. So now I would like to introduce our speaker, Graham Topa, who's a partner at Airden Burles. So Airden Burles is actually one of our partners and a sponsor of the Airden Burles Startup Source Market Entry Award, which is awarded to the top startup in the LaunchU Accelerator program. So we're really excited to have them involved in the Founder Fundamentals series. So Graham is a corporate lawyer who acts as counsel to venture capital funds, banks, and other institutional investors. Graham also advises startups and emerging companies, is a director of the firm's startup group, and is committed to helping clients navigate legal and business challenges. Welcome, Graham.
Thank you very much for having me. I'm going to move over to put my screen on full screen so you can see all the slides and all that stuff now, and then I'll get going. Perfect. Thank you for the warm introduction. I'm happy to be here and excited to be speaking with you today about sort of corporate law basics for founders and startups. Diana sort of touched on my background history. I do a lot of cross-border work. I do a lot of venture capital work. I do a lot of work with institutional investors who are putting money into Canadian companies and helping those companies sort of grow. So, everything from doing a seed financing round, with an angel investor or institutional investor stateside, or a large established venture capital fund looking to make investment to Canadian company, assist with that. Do a lot of venture debt work. So large US banks who operate and provide early term credit facilities to startups. I do a lot of that work. I act for usually the lenders on those transactions. And then with that also act as the company, or as Airden Burles' director of the startup program. So I do a lot of work with early stage companies and founders, helping them get organized, structured, and set up so that they can go out there and really operate with the legal protection and assurance they need going forward. And so what I hope to do with this presentation today is sort of touch on those key legal considerations that founders and early stage companies should be thinking about or have, and to give you sort of a backdrop and understanding as to maybe things to think about on the corporate legal side of things to help ensure that your startup or your business venture is properly organized and structured, so you can be successful going forward. And there's actually a lot of legal considerations that kind of go into that. So I know that most founders are really focused on their business, and they need to be, and about the product or service that they're delivering and their business and its operations. And part of that consideration should go into, think about how you're going to basically maintain control of it if you have a business partner, what things to be looking out for from a legal perspective in terms of those commercial contracts you're going to have to enter into and all that. So we hope to touch on all those things. And I encourage this to be as interactive as possible. I know we got a sort of a large audience here, but to the extent you have any questions, if there's something I say that you don't understand, like ask a question, I'll clarify it. I'm sure other people have the exact same questions, thoughts, things like that you're having, and I'm sure it'll make for a more dynamic and enjoyable experience for everyone. So I'm going to run through this just to start with. I don't know if I touched on it already, but why do we have lawyers, right? So that's might be a key consideration, but we go through the table of contents first. So we're going to talk about business structures, and that includes corporate vehicles or legal vehicles through conducting business. We're going to talk about the incorporation and corporate governance process, what corporate governance sort of looks like and what that involves from shareholders, directors, officers, as well as way to structure relationships between multiple shareholders. So if you and your friend have set up a business or have set up a corporation and you have issues or concerns, or you want to specify what that arrangement looks like with respect to your ownership of the company, with respect to its management, that's something you can address in a shareholders agreement. And it's probably the most important document that any founder will have, especially at the early stage with respect to their corporation or their business on a go-forward basis. And I say that when there's more than one person involved. And usually, when you're going up there as an early stage company, one of the things you're looking to do is to secure financing. And if that financing comes in the form of equity or issuing shares or giving an ownership interest in your corporation to any other person, you really need to start thinking about what that arrangement looks like and contemplate sort of what can happen down the road. And the shareholders agreements is really the instrument that allows you sort of to manage that relationship. Talk about corporate finance. And a lot of what and a lot of that's just more conceptual. Most of what I do is actually in the corporate finance world, which probably sounds more boring than it actually is. We're helping companies and we're helping investors meet, connect, get the arrangement done that they want so that both can be prosperous. And investors are looking usually at startups and early stage companies as a way of generating a high return on their capital or on their investment. And corporations are usually that, and startups are looking at that investment as a way to really excel and advance their corporate interests. So you're looking at getting capital into the company so you can expand your clients, acquire new clients, maybe create a new division of your business, even just work on the product on its core functions, bring on new talent, all that sort of stuff. So it's a key consideration, and it's a key consideration for early stage companies as to how to approach that and approach it properly. I think something that's overlooked is intellectual property, and everyone kind of thinks about trademarks or copyrights or industrial designs or other things like that, patents especially as well. But it's a lot deeper, and there's a lot more to intellectual property than might think about in terms of just having some trademark or patent registered with the United States Patent and Trademark Office or the Canadian Intellectual Property Office. And then the next one is confidentiality and non-disclosure agreements. These apply to early stage companies in almost everything you do. And it's really important to understand the function of these agreements in protecting your startup or your venture and your idea. And then we're going to talk about also commercial contracts. A lot of these things will play into, you may have questions about taxation or about something else that's related to it. And I'm happy to the extent I'm able to address those questions as we go through it. So why do you have lawyers, or why is there such things like corporate lawyers? Why do I have a job? One thing is you're entering into very complex relationships and arrangements with other parties, and we're here to protect your rights, and we're here to protect your interest. We're also here to get you the deal that you want. And so part of that is thinking about things that you may not think about automatically, or you may not have thought about previously, and to really help you understand your sort of what your risk appetite is for a particular transaction or particular arrangement, as well as things you may not have even thought about in terms of how to structure. So a lot of times when I'm dealing with early stage clients, the original first conversation we're having is, what is the arrangement? What is the relationship you have? Do you have co-founders? Do you have, where you operate out of? Is this purely an online platform? Where are your transactions occurring? Are they occurring in Canada? Are they occurring stateside? Where are you, are you licensing intellectual property? What's your business model? And really helping to work out from a legal perspective the actual transaction. And it's shocking sometimes people have a wonderful, exceptionally well thought out business model, but they haven't really thought about it in legal terms. And so the lawyers there are asking questions, are helping to sort of really hammer out what's actually transpiring, whether that's like a drop shipping arrangement if you're doing some online e-commerce, if it's a reseller arrangement, if it's any other type of license arrangement, as opposed to maybe a sale of actual product or service, and how best to structure that. So you have lawyers there. Part of conducting, engaging in business is taking risks, and lawyers happen to be very conservative when it comes to risk taking, and that can be a good thing. And often what you may hear from lawyers is all the reasons why not to do something, as opposed to doing it. And what they're really doing is they're just trying to flag things for you to help inform you so you can make an informed decision about your business on a go-forward basis. So business structures. One of the most wonderful creations, and it sounds really kind of silly, and you probably hear about it a lot in the media, is this idea of limited liability corporations. And it goes back 600-700 years. And the original reason for that was that before that, every business operation was essentially a partnership, and it was a general partnership, and it was people in business together for a particular purpose. But when one of those partners passed away or died, that structure was immediately terminated or dissolved. And so it was very hard to pass on a successful or a successor interest in any type of operation or venture with a view to profit. And so under English law, they came up with this idea of corporations. And originally we can think about them like the Hudson's Bay Corporation or something like this. It was usually set up as a commercial enterprise. I quickly got into state-run or state-owned or operated, but it quickly transformed into something a little more robust where two individuals could have their own interest in a partnership, and they could transfer that interest or it'd be passed on as a piece of property that they would, a personal property they would own. And the reason why corporations afford us, which was really wonderful, is it limits your liability as a shareholder. So you don't need to put your house on the line, or you don't need to put your car on the line, or your computer, or your personal property. You can say, I've set aside $1,000. I'm putting aside $1,000 to run this venture, and I want some assurance or protection that my obligations and liabilities with respect to or as the corporate vehicle or this business going forward are essentially limited to that. So when you hear corporations and you hear limited liability corporations, essentially what it is it's a separate vehicle. It's separate and distinct from you as a person, and they have the ability to own property and to operate and have certain rights as a natural person. But the real value and function is to limit your liability as a shareholder to what you've contributed in form of capital. And so while it sounds probably more academic or legal in nature, the idea is simple: is that your liability personally is limited. And that's something that's really wonderful, especially when trying a new venture and you don't want to maybe put everything up on the line for it right away. So there's different types of business organizations. The first one is a sole proprietorship. That's an individual, just me, Graham Topa, walking out and selling. I will the lemonade stand, and I operate that, and I make money, and it's just personal income. There's no limited liability afforded to me. And it's literally just going out there and generating or conducting a business, whatever it may be. There's no limited liability afforded to sole proprietorship. To register sole proprietorship, you often simply register a trade name. It costs like $50 in the province of Ontario. You get that trade name, and then you can start conducting business using that trade name. Sole proprietorships is one person. If you're in business with someone else, it forms a partnership. You may not even know you're in a partnership, but you might be in the eyes of the law. And really a partnership in its most general basic form is two people or more acting with a sole purpose for, or acting with a purpose to generate income. There's a definition in the Partnership Act that you could get for it, but essentially it's two people in a common activity with a view to profit. And we already talked about sort of corporation. Corporation is the most common form of, or most probably recommended form of corporate organization or legal entity for carrying on conducting business. And part of that is that it's really easy to specify your ownership interest in the corporation, the management control of the corporation. And there's a lot of well-established corporate law around this in Canada for the last 150 plus years. And it's really easy when you bring on new partners to sort of carve up, or not partners, new shareholders, what their rights are, who's in control of the board of directors, and all the other stuff there. There's also, in terms of the organization of society, it's really easy to go get a bank account with a corporation, to do a bunch of things, to register property with a corporation, whether that be a car or a trademark or whatever it might be. Sometimes you hear the term joint venture. A joint venture is, well, it's any of these things. It's not a unique sort of business organization. It's often what happens is two businesses, two corporations, two enterprises, whether that be a limited partnership or joint partnership, might say, look, we want to pursue a common activity here, and it might not be core to either of their own business operations. And so what they'll do is they'll set up a special vehicle often, and that special vehicle will typically take the form of either a corporation that's jointly owned, or a partnership that's jointly owned, or something like that. And they'll use that to pursue a joint venture. I only include it here because people often talk about joint ventures, but it really is not a distinct legal entity of any sort. It's usually an operation people sort of take together when they're looking to pursue a new or unique opportunity.
So Graham, we have a question in the chat, and this person is asking for more clarification on the difference between a partnership and a joint venture.
So partnership is a partnership you can create. So you might create through setting out a joint venture, you might actually create a partnership, but you may not want to for tax reasons or for other reasons. So there's important things when you're ever thinking about doing a joint venture or entering into business with another person with a view to profit, is to clearly spell out that this doesn't constitute a general partnership. And there's reasons for that. One, you can bind the other partner; they can become liable for your obligations. You become liable for theirs. Typically, when you're looking at setting up a joint venture, or you want to pursue a joint venture, you're very clear about what that arrangement looks like and how you're going to pursue it. And that often takes the form of setting up what's called a limited partnership. And it's a little more complicated. And there's reasons for that, where you can contribute, assets or other property to it. And you have a general partner that you would be usually a corporation that's jointly owned and controlled, to ensure that the rights of both of the partners or both of the entities that are looking to form that joint venture are clearly delineated. And their respective obligations with respect to one another are clearly delineated. But I wouldn't put too much focus on a joint venture. You might, the default position in sort of law is that you form what's called a general partnership. And, sometimes without even realizing it, you may have actually formed a joint partner. You may have actually done a partnership. I don't know if that helped at all. But think about legal entities. So the most important thing I think about is with early stage founders and startups is people talk about like, this is my business, or this is what I'm doing, and they have a corporation, and they don't really distinguish or separate when they're talking to potential customers, potential clients, potential investors about themselves and the corporation. And I think it's from the get-go, it's really important to understand that that's a distinct legal entity. You may own it, you may own all of it, you may be the sole director, sole shareholder, and sole officer of the corporation, but it's separate from you. It's a separate taxpayer. It owns its own property. You might own your laptop. It may not own any property at the start, but it's really important to start thinking about it as a distinct legal entity. And then with this, there's consideration that can be given as to where you want to incorporate. In Canada, we actually have legislation at the federal level. The United States does not have that, so you'd have to incorporate in a particular state. Some states, the jokes about Delaware being a particularly favorable corporate state. Part of that was deliberately set up because they wanted to get all the fees and from courts and from lawyers and doing all that. So they created a very comprehensive and refined corporate law statute, and had some of the best lawyers basically sit on judges on that court to basically help put together a wonderful body of corporate law where you're going to basically get a fair hearing, and things are going to be I guess they're just really well thought out when it comes to the organization of corporate. But in Canada, you can incorporate federally, so you can have a federal corporation, or you can have a corporation that's organized under one of the provincial statutes. So every province in Canada has a Business Corporation Act or the equivalent, and you incorporate under that. And the corporation exists by virtue of the fact that it's of those statutes and its relationship to them. The one consideration given to where you incorporate in Canada, we have direct residency requirements in a lot of the provinces. Some don't. So you have like Nova Scotia, we have New Brunswick may not as well, and British Columbia, where you don't have to have a number of resident directors. So if there's a US parent company and they want to incorporate a Canadian subsidiary, sometimes those direct residency requirements become an issue because they don't have a resident Canadian who has to satisfy a certain definition to sit on the board of directors. So what we do is we incorporate in British Columbia for that particular purpose. When you think about where to incorporate, a lot of early stage companies will want to incorporate federally. It's easy to search for. You can go onto Corporations Canada's website. You can do corporate search to see who's got the name of corporations out there. When you incorporate federally, you have the right to use the corporate name that's granted or afforded to you by Corporations Canada or Industry Canada in every province and territory in Canada. So you do get some additional rights with a federal corporation that you don't get with an Ontario or Alberta or British Columbia corporation.
So Graham, we have another question in the chat, and this one is from Cody. They are asking, as a sole proprietor, is there any downsides to registering your business as a corporation? It all sounds positive, but when looking at liability, do you pay more taxes?
So you would pay income taxes. So it'd be on income generated by the business. The one thing some people do when they're starting up is they may incur a lot of expenses personally with respect to a early stage company, whether that's buying a computer, hiring a contractor, doing all that type of stuff to help them maybe write some source code or write some code or build or develop a mobile application or whatever it might be. If those are costs incurred in furtherance of business, you may be able to write those off for tax purposes personally. And so you might lose some benefit if you're conducting, carrying on your venture as a corporation at an early stage, simply by not having the ability to sort of write off some of those expenses for tax purposes. But by and large, if you're entering into any meaningful contractual arrangement with someone else, you're probably going to want the limited liability afforded to you by incorporating. So with that, in terms of corporation, the corporation usually for startups is not making any money, is not generating, is not revenue positive for a number of years at the early stages, and a lot of cash is being sunk into it. You're not paying any, corporate income tax or anything on that at the start. And because of that, really, if you're looking at it as to like when to incorporate, one of the, I think, key legal considerations is for you is when are you going to expose yourself to significant liability or liability that, you find on second thought, I don't want to do that, or I don't want to, put myself on the line for $10,000 or $50,000 or whatever might be your obligations under a particular contract. Like, for example, if you're sole proprietor and you have to buy materials and that, that contract requires you to every month put out, $3,000, $4,000 in materials. Do you personally want to be on the hook for that, or do you want your corporation to be on the hook for that? And if you were to hit a hard time, someone might turn around and try suing you personally for that, as opposed to suing your corporation that really has no assets other than what you put into it on on a go-forward basis. So those are some of the considerations to think about when to incorporate and versus continuing operations on as a sole proprietorship.
That makes sense. And sorry, we have two more questions in the chat. So we've got a question on the benefits of incorporating when a sole proprietor.
Yeah, so the benefits to incorporate when a sole proprietor is, essentially you get limited liability protection. So, and anytime, if you're thinking about or you're working on a business venture and you're not incurring any liability, probably no reason to incorporate. If you are working on something where you're trying to enter into arrangements, they could be commercial contracts, setting up a website that you're going to do commerce on where you could incur liability or something like that, then you need to start thinking about, should I incorporate, should I protect myself? And that's usually the key consideration for early stage companies. The other one is that, you don't want to do things last minute. So sometimes people come to me and they'll say, look, I've done all this work. I've been working on this business venture for 2 years. We've got all this stuff and I'm talking to investors. And I said, have you incorporated? And they'll be like, no, I haven't done that. And I said, well, you've already started to have a discussion with investors. You should incorporate ASAP, put all the intellectual property you've developed in the last little bit, or with respect to this business venture into that corporation now. Get your books and records cleaned up. Get them, get the whole thing looking good, because what these investors are going to invest in is exactly that. And it's better sometimes to have, I think almost always from the founder's perspective, to have a well-organized, well-structured corporate entity that's got all that intellectual property, got all that other property ported into it, clearly sets out, your ownership. If there is other partners you have, or other business ventures, or other people you have who have contributed to it, other founders, to have their rights and stuff all clearly set out in advance of speaking to potential investors, because it makes you look way more sophisticated and can help you in your negotiations by sort of setting the stage as to sort of what you expect and what you want to maintain. So that's another consideration. Really, sole proprietorship doesn't really work if you got another person who's conducting the business with you. So you can employ someone personally, or you can contract with someone to be an independent contractor for you for the purposes of your business. But if you have two co-founders, you're really at that point might be in a general partnership without realizing it, and it's really very difficult to sort of set out your rights and obligations with respect to one another, or to structure your business enterprise without incorporation.
That makes sense. Now I see a few more questions coming in, and we'll get to them, and then we'll let you continue on with your slides.
Oh, no, it's good.
There's lots of questions involving this topic. The next one is from Antonia. If you're incorporated federally, is there anything else you need in regards to legalities to do business nationally across Canada? For example, selling and shipping to BC from Ontario.
So I can speak to generally. So you should always consult a lawyer about specific legal questions. Can't give specific legal advice here. That's my legal statement. But you have to register. So you have to register extra provincially, and it depends on where the transaction's taking place. So if you're organized out of Ontario, you're incorporated federally. You're a federal corporation. You have a registered head office in Ontario. When you incorporated, you would have had to register extra provincially in one of the provinces. So you probably would have registered in Ontario for your extra provincial registration. It's essentially, it registers your corporation as operating doing business in the province of Ontario. Depending on the nature of the arrangement you have, you may not need to register in British Columbia if you're conducting e-commerce or providing some sort of like service, if that service is being provided in Ontario and it's done digitally or remotely or whatever that might be. So there may not be any registration. If you are bricks and mortar operation, you're opening up a storefront in BC and your Ontario corporation, you really should register extra provincially. And so that means that you would, and there might be reasons why you have to do this, like Quebec, for example, you have to do that register because you're going to need to get a QST number, so their form of harmonized sales tax, things like that. So and that step is usually pretty easy. I'm in the process now of setting up a bricks and mortar, or helping a large client organize a bricks and mortar operation, and we're registering extra provincially in every single province and territory in Canada because they're going to conduct business in all of them. So that's usually the one thing you need to think about. And then depending on the nature of your business, you might have other requirements depending on the type or nature of activity you're engaged in. But generally speaking, most startups will need to be extra provincially registered in their jurisdiction of incorporation or where their registered head office is.
Okay, and the next question we have is from Zarin. How do you incorporate a social enterprise?
So I don't really know what a social enterprise means from a legal perspective. You can register what's called not-for-profits, and I didn't really incorporate here because it's really not a business vehicle that is often used, because the shareholders or the owners of the business can't retain or the dividends can't be paid out there. It can't be used to conduct a business in the traditional ordinary sense of generating a return for the investors or shareholders. You can register under the Not-for-Profit Act in Canada, and you could do that, and there's various reasons why you want to do that. Maybe you get access to government grants, maybe you get access to government money, and so there's ways to structure a social enterprise, or it doesn't need to be charitable. It could be essentially you're running a not-for-profit, and you could specify whatever that social enterprise may be. It could be work in theaters or the arts, or it could have a social justice mission for helping disenfranchised people or homeless people or people who need help. And you can register that as a not-for-profit. That might be the best thing to do if you're looking to get some sort of government grant or funding. But for the most part, when we talk about sort of business ventures and carrying on a startup for a business purpose, we would strongly recommend incorporating with a limited liability corporation.
Okay, and I'll take one more question and then I will let you go through some of your slides because we do have a
Oh, no.
presentation to go
Yeah.
through. But the next question is from Fred. As a sole proprietor, could insurance less expensively replicate the limited liability benefits of a corporation? Or are there limitations on how far coverage goes?
So it depends on the type of insurance you get. If you get general commercial liability insurance, that's great. Remember, insurers are there to collect premiums and deny coverage, right? So you're on an uphill battle, and they're going to be looking for any exclusion under insurance. Like I deal with insurance a lot, or with corporations dealing with insurance. They're there really to deny sort of premiums or coverage. So while you might pay, and it might be a good idea, and I'd certainly recommend all corporations, once you get to doing material operations, to obtain general commercial liability insurance. You're in a fight, and you're already in a fight, and I think the last thing you personally want to be thinking about is this going to bankrupt me personally, or can I rely on my insurer to come save the day if there's a liability claim made against me. If there's a liability claim made against, or a claim made against your corporation, you can essentially say, well, I tried this business venture up, I don't know if I can proceed with this lawsuit now against me. I'm going to close this down and start up a new venture, new operation. So I mean, there might be circumstances where it makes sense to supplement what you're doing, but I think the insurance, not the insurance, but the protection afforded to you by a limited liability corporation is in my opinions far superior.
And I do see some more questions in the chat, but Graham, I'm going to leave it up to you whether you want to continue with some of your slides and maybe take another break for Q&A after them, or if you want to take them now.
1 second, I don't know how to get this back. Let's see what the next slide was. No, we can take another one. Let's do that. I'm just going to talk about the incorporation process. So happy to take some more questions.
Okay, perfect. So this one's coming from Will, and he's wondering if there are any legal considerations that should be thought about in regards to doing a business with a romantic partner.
Yeah, a lot. I mean, or even just a friend, right? Like if you know someone and you have it, and that actually plays into this next slide in the incorporation process as to what's involved. Well, think about what happens if the relationship breaks down, right? Or if you don't want to be in it, like not the relationship, but the corporation anymore, and you want to pursue some other venture, or like Google knocks on your door and says, "Hey, I'm going to give you this crazy job, but you got to leave what you're doing." What does that do to your your business venture you've got set up with your romantic partner or friend or whoever? All those are things that you need to kind of, or should think about up front. And often, when founders or people are working on a business venture together, they kind of put these questions off or don't want to think about them. And it's one of the reasons why it's important to talk to a lawyer, because the first question I have when two founders come to me is, okay, so what's the arrangement? And they might say, what do you mean, what's the arrangement? So, well, who owns, what percentage of the business or shares of the corporation do you own? What percentage do you own? Who's in charge? Like, are you both directors? Do you have an equal say and voice and everything going forward? And a lot of these things they haven't thought about, right? So those are all things that those are all questions that I think are really important, especially when you're thinking about, working on a business together with someone else. And that kind of goes in the incorporation process. So, like, talk generally. Corporations are formed by the filing of what's called articles of incorporation. And then that's a legal filing that's made. And then at that time, the government, whether it's the Ontario government, BC government, or the federal government, is going to issue you a corporate name. And that can be, depending on what you want, it could be a name that you want, like ABC Corp or Ayrton Burles Incorporated. There's some requirements on the name. You see those things like Corporation, Inc., Limited, or abbreviations of Incorporation, Limited, or Corporation. There has to be there for a corporate name, but if you don't specify, you'll get issued a corporate number. They're exactly the same thing, other than we talked about already. The federal corporations, you get the added benefit of having the right to use that name in every province and territory across Canada. For your business. The part of the incorporation, in addition to filing the articles of incorporation, in those articles, it's a really important legal document when you have more than one shareholder. Even when you got one shareholder, it's an important legal document. You can always fix them afterwards, but the articles set out, basically they're the guts of the company. They're the guts of the corporation. They set out your share classes, and those share classes will have the share terms, which will specify voting rights, rights to property of the corporation on its dissolution or wind up, dividend entitlement rights, which is basically how you're going to, as a shareholder, receive payments from the corporation. And they can be really complicated or really simple. And usually for startups, unless there's some really pressing reason why, I like to recommend that you get basically the simplest, just have one set of vanilla common shares, and that if there's multiple shareholders, you deal with respective rights through a shareholders agreement if there's going to be something different. And there's a lot of reasons for that. It's not like like an outcomes razor type thing, but the idea is that the simplest, there's no reason to make things more complicated from the start. And later on down the road, when you get investors in, they'll come in there and they're going to probably, add in share terms, add in share classes, do a bunch of things to reflect the business arrangement you reach with them with respect to their economic entitlements, rights, and privileges and all that. So as part of, so one thing you do, you follow these articles of incorporation, you get a corporation is created. We talked about you register that corporation, or will register that corporation within the province, and that it's incorporated, as well as if it's federally in the province in which the head office is. And then there's a bunch of other corporate documents. So if you go talk to a lawyer, they should help you sort of prepare, at a minimum, the organizational documents. So that would be resolutions, director consents, bylaws, shares. If you're going to have the shares certificated, they don't need to be certificated, share certificates to evidence the shares you issue. And then the most important thing, which isn't necessarily part of the incorporation process, but it is part of the organizational process, is a shareholders agreement. And that's the agreement that you have among some or all of the shareholders, and we'll talk about later, but that's the instrument agreement that's going to allow you to maintain control of your corporation on a go-forward basis, because this is probably something you're investing a lot of time, energy, and money in, and you don't want to lose control of it. And so that's what really comes into place. But the incorporation process, you file articles of incorporation, the lawyers prepare some documents that really evidence and reflect that arrangement, who's the directors, who are the officers, the shares being issued at the time of incorporation, and all that goes and forms part of the minute books of the corporations or its corporate records. It's really important to keep good corporate records, because at some point in time, someone's going to want to look at your corporation, and this is basically everything happens. While you and me as natural people can go out there and just make decisions, corporations typically document what's transpiring, what's happening in terms of the decision making, or in terms of their undertakings or decisions, take certain material actions in the form of resolutions or written documents. And so these are, while they're legal documents, they're really important documents for anyone who's looking to invest in a corporation, or even just in good corporate governance. So once you incorporate, kind of touched on that, whenever you are incurring material liability or any liability you're uncomfortable with, you should incorporate. The other time to incorporate it, I think, is when you want to properly structure a business relationship. So you have, as we talked about, a business partner that you're pursuing for a particular purpose. And you say, look, we're going to get in business together. We want to make widgets. Let's do that. Here's what we should do. We should, first of all, incorporate at that time so you can clearly set out your rights and responsibilities with respect to this. Often, sometimes people will come, I won't say too late, but you've already invested a lot of times or interest in a particular venture, and it kind of gets off the rails, and you want to take in one direction, you want to take another direction. And while a corporation doesn't prevent those disputes from arising, it might, if you've gone through that discussion already and thought about those things, it might help you sort of address or deal with issues in advance of them actually coming up. So usually, if you're anytime you're going to incur material liability, or you're looking at starting up a business venture with another person, you should start to think about incorporating.
And the next question is a little bit related to that one. It's coming from Juan, and he's asking, how do you convince a family member, or any tips to convince a family member to sign a contract? Because as a family member, they usually don't think it's necessary.
It might be hard to ask a clarifying question, but is that family member giving money, or is that family member helping out with the corporation? I'd have to know what sort of relationship it is. Family members who invest money should be treated like any other shareholder, and they should document stuff. So, in the context of that, if the family member is providing, it really depends on the corporate document, but you shouldn't give preferential treatment in the form of having sort of, undocumented transactions with family members if you would document that transaction in writing with someone else. I'm happy to address that if there's a particular situation, like if that's a share issuance, or if it's a family member sitting on the board of directors, what that would look like. But I wouldn't treat family members any differently than anyone else.
Okay, and another question is coming from Thomas, and he's asking if you incorporate federally, is there any reason why you would have to incorporate provincially as well?
You wouldn't. So you can only incorporate one corporation under one governing statute. You can move a corporation from one jurisdiction to another, from federal to Ontario, but it's costly, time consuming, and really unnecessary unless there's a particular reason that you want to do that. And that's called continuance. And the only time you really would continue or do a continuance of a corporation to a new jurisdiction if you were probably looking to amalgamate or do something else, or you want to avoid some regulation or requirement in the Business Corporations Act statute, for example, director residency requirements. So if you foresee in the future not having any resident Canadians on your board, you might move that corporation from Ontario out to British Columbia, for example. But once you incorporate, you're organized under that governing governing statute. So if that's federal, you're just a federal corporation at that point.
Okay, and we have another question. So just two more questions. Sorry,
Yep.
Graham. Coming from Aaron, if you have a corporation and you sell products through your employees and you offer a percentage per product sold, how would you pay out that percentage from a payroll perspective and taxes due to a double taxation from a C Corp, similar to working for a car dealership and getting 20% for every car you sell?
So this is a pretty specific question. Typically, if you have sales agents, I'd have them structured ideally as independent contractors of the current corporation. Part of their fees for providing services would be structured in the form of commission or a percentage of the sales they've engaged in, and that'd be paid out like any other payment to that independent contractor. So if that independent contractor had a set, base, wouldn't want to call it salary, but you're going to pay them X amount per week, then, in addition to that compensation that are being provided, they're being provided not a bonus, but an amount equal to whatever it is, 20% of the gross sales they generate for that month, and that just becomes a corporate expense. So it's not coming off your bottom line. It's actually a cost you're incurring to do business, right? So it's a cost center. So when you're conducting or computing sort of income tax purposes for the corporation, you wouldn't be looking at sort of double taxation there. That's just an operating expense you'd have. It's a cost center.
Okay, and we have Amaka who's asking, what is the easiest way to source a business lawyer for a consultation in business startup phase, especially pre-partnership?
So you should, you call me. I'll give you my time, and I'm happy to get on the phone, every week with a couple, founders, startups, whatever, and just talk to them for 15, 20 minutes and understand where they are, and they get to, use me as a sounding board for what they're doing, even if they don't engage. You'd be surprised. There's like lawyers who sit in these like ivory towers down on Bay Street or wherever. They are very approachable, and if you look at sort of, you can Google any of the top firms like Evan Brolis, there's people there who'd be happy to give you a consultation or talk to you about what it looks like to incorporate or use their services, and you can have a conversation. I encourage people, especially early stage companies, if you're thinking about engaging, just reach out and say, hey, here's where I'm at, just want to know if you can help me. They might say no, or they might say, look, I think you're too young, or here's our fees, and maybe it doesn't work for them. But look around. The internet's a great place. There's great law firms out there. There's great lawyers out there. You may not want to call, a senior partner who's been practicing private equity M&A at a top firm, but you may want to, reach out to an associate who's been practicing for a couple of years, who's working, on their bio or whatever with venture capital transactions, or who works with early stage companies, or who does that. So, I mean, I'd encourage you to reach out and try to, just email people, pick up the phone, call them, leave them voicemail. Lawyers are hungry too, and the people who are out there who are, they're operating usually for the most part a business themselves, and they're looking to get new clients. And if you reach out to them, pick up, you'd be surprised. You get a lot of good, positive feedback, and they'll call you back and they'll talk to you about what's going on. And if you like what you hear, you should think about engaging them.
Okay, and last question we're going to take for this portion is from Jacob. If you incorporate, are you obligated to get insurance?
No, there's no, you can incorporate and you have no obligation to get insurance. You can incorporate and do nothing. You can literally incorporate and do nothing with your corporation. If you don't make the necessary government filings, the government may dissolve it or wind up the corporation after a number of years, because they'll just say you're not complying with the laws for failure to pay the annual filing fee of $40 or whatever it might be, and we're going to dissolve the corporation. But you don't need to get insurance, and you don't need to take any actions with the corporation or do anything with it once it's incorporated, other than, I mean, you might, if it's carrying on activities and things like this, make some tax filings and do things else. And it doesn't, there is obligations down the road and with respect to winding up the corporation and all that and record keeping. But for the most part, you don't need to make any outlays of cash or obtain any insurance or anything like that.
Okay, Graham. So I think I'm going to let you get through a few
Yeah.
more slides, and then we'll take another break for the rest of the questions.
Yeah, so I think corporate governance is a really and big question, or it's a really important topic. When you think about corporate governance, often what happens at early stage companies, you're a shareholder, you're also a director, and you're also an officer. So I don't know, people are sort of directors versus officers. I'm the president, CEO of the company, whatever it might be. Most startups, if it's a single person who's creating that business venture, doing whatever, is the sole shareholder, is the sole director, and might hold multiple offices. They could call themselves, chief technical officer, chief executive officer, president, and they can hold all those hats. So part of when you set up a corporation, especially when you have multiple shareholders or you have multiple interested parties who are involved, like co-founders, internal corporate governance is really, really important. And one of the things that you do with that is understand the roles and responsibilities of various persons. So for example, shareholders have rights and they have very limited responsibilities. Shareholders, their rights they're set out in the corporate statutes. And they can get additional rights by virtue of a shareholders agreement as well, or an arrangement which is among the shareholders and the corporation. But the rights and responsibilities of shareholders, in terms of rights, you can approve annual financials, you can approve auditors. Most importantly, when we think about corporate organization, shareholders are the ones who appoint the directors. And shareholders don't have say in their capacity as a shareholder over the actions a corporation does. What shareholders do is what rights they have is they get to appoint the directors who manage the affairs and business of the corporation. So off the start, the default position is if you have a majority of the shares, or 50.01% of the shares of a company, you get to appoint the entire board of all the boards of directors, so the entire slate. So if that's 3 directors, if you have 50.01% of the shares, you get it. Think of it like that's the best way to think of it. So if you get to appoint all the boards of directors, the board of directors then controls the corporation. The majority shareholders. With a shareholders agreement, you can carve that back a little, and we'll talk about sort of what that looks like. Shareholders don't manage the affairs of the corporation, directors do. And again, you might be the sole shareholder and sole director and sole officer, but it's important to understand that you wear different hats at various times for various functions. Because shareholders don't take responsibility for the management of the corporation, they're not responsible for it. And so part of that benefit is the fact that you have the limited liability protection afforded to shareholders. It also allows multiple shareholders to have to come together to do certain things, like elect directors. Sometimes if the corporation is going to take material action, like action that could impact the shareholders by creating a new class of shares, changing the business operations, things like that, winding down, you need to get what's called a special majority, which is 66 2/3 of the shareholders to agree to that action. And those provisions are in the Business Corporations Act, and they're in there really as protective provisions for shareholders to ensure that there's sufficient consent amongst the shareholder group to vote to take for the corporation to proceed to take that type of action. So rights and responsibility of directors. Directors they're the people who manage the business and affairs of the corporation. Directors only give up their authority to officers like presidents, CEOs, things like that, by delegating their authority. So the buck stops with the directors. They're ultimately responsible for the management of the corporation, and there's certain responsibilities and duties that they can't sort of delegate. They can't, for example, directors have to authorize the issuance of any shares or securities of the corporation. There's other responsibilities that they're always sort of going to be responsible for. And any action taken outside the ordinary course of business would need to be approved and authorized by the board of directors. So often what lawyers are doing and corporate lawyers are doing is we're advising really the board of directors when we're advising or acting for the company as to, what the rights of the corporation are or how best to structure a transaction, because they're the ones who are, really for the most part, making those decisions. Sometimes, for day-to-day responsibilities, officers will often be responsible. Again, it could be the same person, but the directors are responsible for the direction of the corporation, like a business plan, hiring the right people, driving the business forward. So when we talk about sort of carving up the rights and responsibilities from a shareholder's perspective, one thing that you'd want as an early stage founder was to make sure that you got a seat on the board of directors, and maybe to make sure that you got a control and interest on the board of directors, so that you as the founder or as the founder group can ensure that you appoint a majority of the directors. Same with shareholders. The default position for directors is that a majority of the votes at any meeting of the directors carries the day. So we often, when we're advising corporations, say it's best to structure your board such that there's an odd number. Usually it's 3 or 5 for an early stage company, so that there's not deadlock there. And sometimes when you get other parties come involved, like institutional investors, and they're putting in money, they might say, okay, we want the right to nominate, not a majority, but we want the right to nominate 2 directors, and founder group, you can have the right to nominate 2 directors. And this 3rd director will have as an independent. And essentially what that's there for is to, ensure that that director can impartially look at and evaluate the matters confronting the corporation, and that there can be, some sort of 3rd party to sort of weigh any dispute that would arise, and not like a legal fighting dispute, but some sort of disagreement as to the direction the corporation should go with a particular matter. So that's there in terms of the directors. Officers, as I mentioned, officers receive all their responsibilities from the board of directors. So often you'll see someone signing a document as president. That person, if it's a material transaction, material document, they would, or a material agreement, they would have to have basically been imbued with the power from the board of directors to execute that. So part of what directors, the board of directors would do would authorize any officer director to, complete this transaction or execute any document in connection with it. Officers are often, they're the people who are responsible for connecting with other employees, for really marshaling out the business plan that the board of directors or the direction the board of directors want to take with the corporation. And again, early on with most early stage companies and startups, the board of directors and the officers might be the same people. So if you have 3 founders, and that's all the shareholders, you might be the shareholders, you might each of you be a director, and you might each be an officer holding a different title. It could be co-CEOs, could be president, vice president, secretary, chief technology officer, all that's it. And these are usually titles that you may want to, when you're going to share. So if you're primarily responsible as your role within the early stage company or startup as you're the tech guy or the tech girl, then you might be chief technology officer. Someone else is, really driving things from a, business structure perspective, or from, partnering and teaming with someone else. Maybe that person wants to be identified as president. There's really no additional rights or privileges afforded to these offices, absent anything in the articles. So sometimes, articles, I'm in bylaws. So, which is another organizing document that kind of sets out the rules for how the corporation internally functions, like who has the authority to sign documents, or who has the authority to sign checks or instruments, how meetings are conducted, how shareholder meetings, how board of director meetings are conducted, things like that. It's just kind of a legal document that helps clearly delineate the rights and responsibilities of all these major players involved with the corporation. Happy to address any questions people have about it. I think startups often really, it's hard to kind of wrap your head around, like, but I'm the director, I'm also a shareholder, I'm also the officer, and what those things mean. But you'll see sometimes lawyers will say, like, you got to sign all these documents. And the person says, like, I'm signing this document as a shareholder, I'm signing this one as a director, I'm signing this as an officer. There's a reason for that, and it has to do with carving up rights and responsibilities in terms of the corporate governance. And when you start to bring in, friends and family who might be investing, or you start to get institutional investors, all of a sudden, as the corporation grows, you'll become much clearer as to, what the function of these people are and why it's done this way. But essentially, the buck stops with the director. Officers are responsible for day-to-day operations, and shareholders essentially elect the directors of the corporation. And that's kind of how it's carved up. Happy to address any questions anyone has, or talk about sort of officers, directors, shareholders more.
Yeah, so I don't see any specific questions about this segment, but we did have 2 previous questions that we didn't get a chance to get to before, so we can address them now. This one was from Sue. When is the federal incorporation better than the Ontario incorporation?
So, good question. one advantage, so there's a couple things. One thing is federally, it's very easy to search. So if you can easily go on. Some people I've experienced have they don't want their name out there tied to a corporation as director, as an officer, things like that. So the records for a federal corporation are much easier to search currently right now, and you can search an Ontario corporation and get all the same information, but you got to pay a search fee, and it's a little more. You can't just do an internet search and get that information. So there's that. The real benefit afforded to federal corporations is the right to use that name in every province and territory. So it's almost like it's not the same as you would get like protection or rights afforded with a trademark, but at least you can operate using that corporate name in BC as well as Ontario if that's going to be an issue for you. In Ontario, you're not afforded that same right. So you could have Graham Topa Corp in Ontario. You could also have a Graham Topa Corp incorporated in BC. When you want to go incorporate those entities, the second one might be well advised not to use that name, knowing full well there's an Ontario corporation registered with it. But you're never going to be able to be issued a similar name or identical name federally as any other corporation existing in any province or territory. So there's additional costs incurred associated with that just on the upfront in terms of searching, but that's essentially it. Otherwise, you get the same rights and benefits afforded for you as having a limited liability corporation under both statutes or any of the provincial statutes and the federal statutes.
Okay, great.
Some people like to have some people like to also have a federal company. They feel it's easier to attract investment, and there's I don't think that's true from my experience, but the people certainly seem to be incorporating federally much more now than using provincial statutes, at least when it comes to setting up early stage companies.
And next question is from Keisha. She's asking, can you change the name of an incorporation?
Yeah, so you can change the name fairly easily, especially early on. You can change the name anytime. It requires following what's called articles of amendment, and those amendment become a document, so it'll track the name change. So your corporation will be named, 1234 Canada Inc., and you want to change it to like Graham Topa Corp. The shareholders would pass a special resolution authorizing the filing of articles of amendment, and then the corporation could proceed to file those articles of amendment to change the corporate name from 123 Corp to Graham Topa Corp. And going forward, once those articles have been filed, the name of the company is Graham Topa Corp, and you don't need to refer to it as formerly known as or previously called, anything like that. So you can always change the name afterwards.
Okay, and what about the ownership? So can you switch from sole proprietorship limited to incorporated while keeping the same business name?
So sole proprietorship is really not corporation. So like if you're talking about going from like Graham Topa Corp to Graham Topa Incorporated to Graham Topa Inc. as a form of a corporation, or like ABC Corp to that's your corporate name. So if you wanted to instead be known as Inc., which is simply a short form for incorporated, you could do so. You just have to file articles of amendment. So I mean, it's really, often when people are talking about Inc., Corp, Incorporated, Corporation, it's really just a preference as to how they want that name to sound or look when described either on paper or saying it.
Okay, and the same, actually, the same person's asking this question. Would you think it makes sense to start as a sole proprietor and grow into incorporated personal business?
Look, the only thing I think the reason why if you're going to hold off on incorporating is that there is cost down the road associated with winding up a corporation. So you're going to pay, even if you do it yourself, $400 or $500 to incorporate. You then have an annual filing fee, depending on the jurisdiction. It's not too much, less than $100 probably in those various jurisdictions to maintain the corporation status. So it's the government won't dissolve it. If you're okay with those fees, I think it makes sense. And then on the back end, to wind up the corporation, there's some filing fees as well. And if you can do this on your own, I wouldn't recommend it. I'd always recommend you go talk to a lawyer and incur those costs, because it'll be done right from the start, and it actually costs more to fix it afterwards than it does to sort of get it right the first time. But if you're not 100% on your business yet, or you're still working out the business model and other things, there's no need to rush to incorporate. I think the best measure for this is, are you entering into material agreements for your business? Are you entering into like a distribution agreement? Are you entering into a software developer agreement? And if you're starting to enter into material agreements and you're really starting to drive this thing forward, then that's the time to, I think, start to think about incorporating.
And next question is from Sue. Are there any benefits to a Canadian company to incorporate in the US?
So you can't, as a Canadian company, incorporate in the US. You can incorporate a US company or subsidiary, but you have to be very careful about that for all sorts of reasons. There's tax reasons, there's, you'd have to, and we do it often, but we do it often in the context of a particular purpose. So if the client was going to set up US operations and they had to do so for a US client or customer, we would incorporate in the United States and structure it that way. Usually that's a subsidiary corporation, or that US corporation or Delaware corporation or New York or California or wherever it's organized is owned, 100% of its shares are owned by the Canadian parent corporation or Ontario parent corporation. But off the start, I would, you don't really often need to do that for any particular reason. You can, and almost all businesses can, business models can have a Canadian corporation or Ontario corporation or where it might be, operate stateside, especially on e-commerce platforms or other things. And there's no problems with that. You may need to register depending on the nature of your activities in a particular state, but very rarely would you need to set up a US subsidiary. If you're hiring US employees, which is again something you need to think very carefully about, and especially how to structure your business from a tax perspective, so you're not getting, so you're getting the tax treatment right. You can do that, and there's reasons for that. I mean, when we set up U.S. corporations, it's often in the context of the not just doing U.S. sales or not just doing U.S. engagement, but actually for accessing a particular contract that's only available with a state player, and they need to contract with a U.S. entity, or to have IP registered in the States because there's a particular reason with a licensing agreement or other arrangement that it has to be located in the States, or there's U.S. employees and we need to have a U.S. subsidiary set up for that purpose.
Okay, and I saw another question just came in from Zareen. If you're a fully online platform operating not only in Canada, but also working internationally, can you advise on how to proceed with incorporating this type of business federally versus provincially? Are there any other factors that you'd have to consider?
Not really for that one. No. The answer is no. You could incorporate federally, provincially, that'd be entirely fine. If you want, again, I'm trying to think about the shipment distribution things. If you want to ensure you can operate using that name in various provinces where you may have, I'm trying to think, like even a warehousing agreement, something like that, you may want, from an operation perspective, not really. If you're going to be selling direct to consumers and there's going to be name brand recognition, we'll talk about it later, but you may really want to think about trademarking. But that really doesn't go into a sort of a consideration as to where to incorporate. So I think you'd be fine to incorporate federally or provincially with respect to that business model.
Okay, great. And those are all the questions we have so far in the chat. So feel free to continue with your slides.
Thanks. So most important agreement you're going to have, when I think about startups, I think about primarily, okay, someone's got a business idea, they're incorporated, or they're going to incorporate. When they come to me, they're often thinking about incorporating, or they will incorporate or have incorporated. Often people come to me as a group of founders and say, look, can you act for us? We want you to help us incorporate. Immediately, as soon as there's more than one founder or more than one shareholder, immediately you should start thinking about a shareholder agreement. I think, it's imperative, and everything, anywhere who's doing their client justice when I come to them as a founder would say, you really need to think about a shareholders agreement when you have more than one shareholder. This is the one, probably most important document you'll ever have, especially at the early stage with respect to your business. It's how you, or your corporation, it's how you ensure you have control of your corporation. It's how you ensure that you retain control of your corporation going forward. How you ensure that, if you have business partners, they're not selling their shares. So example, a shareholders agreement is an agreement among shareholders with respect to typically their shares in a corporation and the business and affairs of that corporation. It can be among certain shareholders, or it can be among all the shareholders as well. Once among all the shareholders, that's what's called a unanimous shareholders agreement. And that has a particular legal meaning. And there's certain things you can do with unanimous shareholders agreement that you can't do with a regular shareholders agreement. And we'll get to that. Typically, the most important provisions to include in a shareholders agreement are restrictions on the transferability of shares and on the rights to maybe vote your shares a certain way, to appoint directors. So if this was an Ontario corporation or federal corporation, I would strongly recommend, if there's more than one shareholder, that they get a shareholders agreement, and that shareholders agreement be a unanimous shareholders agreement. And unanimous means all the shareholders are party to that agreement. And when you have a unanimous shareholders agreement, you can restrict the powers of the directors to manage the affairs of the corporation as well. And you can also ensure that way you can have protective provisions in there for certain shareholders. So one of the things shareholders agreements allow you to do is to restrict transferability of shares. So you can have a right of first refusal on a share. You can have the right to participate in financings going forward. You can have director nomination rights in there as well. So you can, with a unanimous shareholders agreement, for example, say, as long as I own one share, notwithstanding the fact that that might be 0.001% of all voting shares or less than 50% of voting shares, I have the right to nominate 2 directors. Or you have 2 founders. You got Jill and Joe, and they incorporate a business. And there's, they're both thinking about how do we structure this going forward. And Jill says, look, I think, I want to be a director, period. And Joe says, I want to be a director, period. And say, okay, great. And, let's ensure that let's ensure that we can always remain a director, even though notwithstanding the fact that I have less than 50% of the voting shares and you have less than 50% of the voting shares. You can hard code those director nominee rights or director appointment rights into a shareholders agreement. So that essentially ensures that not only as a shareholder, I've got a seat at the board of directors, and I've got a seat at the management table as to how the corporation is structured. Often with shareholders agreements, especially on unanimous ones, you structure them where, notwithstanding the board of directors might want to take a particular action, and this is where it becomes really important for like Jill and Joe. And let's say they got 3 or 4 other minor shareholders involved in the company. You can say, notwithstanding the fact that the board of directors has decided to license agreement, issue additional shares, I, as a shareholder, Jill or Joe, you have to come to me and get my consent with that. So those are protective provisions we include in a shareholders agreement. And essentially they're there to say that, we appreciate the fact, or I appreciate as a shareholder, the fact that there's the board of directors has certain responsibilities with respect to issuing shares and things like that. Notwithstanding that, I need to protect my investment in this corporation, and I want to ensure that I have the final say on that matter. So what you often have is, when unanimity is required among certain shareholders or among all the shareholders, we take that power back and we say the shareholders, by virtue of the shareholders agreement, their consent is required or their unanimous approval is required for that action. There's something that people should let you know about that is that if you take power out of the hands of the directors, the shareholders then become liable or responsible to exercise those in accordance with sort of the standard of care and the fiduciary duty that directors otherwise have. But it was a really important agreement, and it's really important because it allows you to control sort of the organization of the corporation and its corporate governance on a go-forward basis. It also lets you structure and ensure that your equity investment in the corporation is protected. So, the corporation can't go issue additional shares or can't create another class of shares on top of your common shares without your consent. So often, early stage companies, they'll have regular common shares, and some investor will come along and say, look, we'll put money into your company, but we're going to invest on what's called preferred shares. And those preferred shares, as the name says, have some preferential rights. So they may say, before the common shareholders get any dividends, we need to be paid out, X amount of money, or 1.5% our investment, or sorry, 1.5 times our investment amount. If you, as a shareholder, aren't comfortable with that arrangement, or you don't think that's in the best interest of the corporation, you can, have restrictive or protective provisions in your favor put into the agreement. The other thing that really important does, it doesn't allow one of your shareholders, if you have the share restrictions incorporated into a shareholders agreement, to transfer his or her shares. So I'm doing this business venture with my good friend or my romantic partner or whatever it is, but I don't necessarily want to be involved in this enterprise on a go-forward basis with their mother, or with their father, or with their friend. And so I don't want that person transferring his or her shares to someone else. And you can protect against that. Or you can do a bunch of other things. What happens if a shareholder passes away? What happens if a shareholder becomes insolvent? What happens if a shareholder becomes subject to like a family law proceeding, where their shares may be then subject to some sort of transfer? All those things you can take into account with a shareholders agreement. often shareholders want some additional rights, saying, look, I put in some money or I put in time commitment to the corporation. I want to ensure that going forward, I'm offered the ability to, maintain my ownership interest in the company or allowed to participate in equity financing, things like that. So you can put all that in there. And, depending on the nature of the arrangement, you can put in a lot more. You can say, rights to buy out a shareholder. You could say, if you leave the company, does the corporation have the right to repurchase your shares, which is what we kind of call in the startup world like a reverse vesting arrangement, something like that. So there's a lot you can do with it. But it is a contract. It's an agreement among the shareholders and the corporation, and it's the way that I think you can. It's almost essential for the purposes of ensuring that your corporation on a go-forward basis is organized in such a way that you can retain control of it and that you can sort of set the rights. It's also a great tool when you're talking to investors down the road, saying, "Here's our shareholders agreement," and it sets the stage for the organization of your company, maybe post an investment round. I have these rights now currently. I want to retain these rights, or here's the deal that we've worked as a founder group. I think there's almost no situation I can think of, even if it's a very small enterprise and that you don't want a shareholders agreement in place. So I'll leave that there and happy to address any questions people may have.
I do see one question in the chat from Kristen, and she's asking if you have any recommendations for books or any other resources for entrepreneurs that they can use as a reference for these topics.
That's a good question. I don't, lawyers write articles all the time. And if you Google and you can find articles from, there might be some online things. Usually if you see it from a reputable law firm, it's a good thing. There's all sorts of like legal books, but they're really geared towards more lawyers for legal drafting or considerations on high level topics. I think the best thing to do is if you can find a shareholders agreement online, especially if one for a Canadian company and you're interested, read through it. It's a legal document. You're not expected to be able to even like understand the base of it or the complexities that go into it. I remember I started out I was involved in a startup a long time ago in a different life. It was a cocktail bar in Toronto. And I remember entering into this without any sort of legal background at all. And I really didn't understand what I was reading. And I remember I read it over 3 or 4 times, the whole agreement, and I started to understand pieces of it, but really couldn't understand the entirety of it. And a lot of what it was is I just didn't think about sort of what happens in different situations. And that's really what I was contemplating, like tag along rights. So like if one shareholder sells his or her shares, can like I sell my shares in that same transaction? Things like that. It's a legal document. I would strongly recommend you get a lawyer or have a lawyer act for you to draft a shareholders agreement. There's different shareholders agreements for different types of like corporations, and I don't mean that as like a corporation from an early stage company will have a different shareholders agreement than a private family owned a corporation that's being run for a private family business, where those shares are held amongst various family members, brothers, sisters, parents, uncles, things like that. It's going to look very different than a shareholders agreement that's being properly set up for an early stage company or a startup that's looking to go out and get seed capital financing. So there's considerations like that need to be, or even just a shareholders agreement for 2 founders. It can be really simple, it can be or really complex. And I think if you again don't need to have it overly complex, you don't make it overly complex, but it should address sort of the key issues that you would want to deal with, with your business partner, in terms to who's got control over management of the corporation and what happens, with respect to transfer of shares and things like that.
Perfect. I don't see any more questions, so feel free to continue.
So we already kind of touched on this, and apologies for not hitting the slide earlier. So the shareholders agreement unanimous shareholders agreement, kind of talked about that. In order to restrict the powers of the boards of directors, it has to be unanimous shareholders agreement. And that's something that you only really see in not only see, but some jurisdictions like British Columbia don't have that concept in their corporate law statute. There's something else, a voting agreement. We kind of mentioned that. You often incorporate that into a shareholders agreement, but it can be a separate agreement. It essentially is an agreement among the shareholders as to how they're going to vote their shares with respect to certain matters, i.e. the election of directors. So you can all agree as shareholders that, look, we'll all vote our shares for Graham Topa's nominee to the board of directors. So, Jill, Joe, and their other shareholders can all enter into a voting agreement, or there could be voting agreement type provisions in a shareholders agreement that say, we agree up front that we will vote our shares to elect or appoint Jill's nominee to the board of directors. And that's what that is. There's these deconstructed agreements. This is because the United States typically, I mean, a lot of the jurisdictions don't have the concept of a unanimous shareholders agreement. So they trifurcate or separate out the various typical provisions you'd see in those agreements. So there's an investor rights agreement, a right of first refusal agreement, an information rights agreement. Further to the questions I want to ask a moment ago, if you actually want to go on and you want to find maybe the best example for a unanimous shareholders agreement or investor rights agreement, right of first refusal agreement, go on the Canadian Venture Capital Association, CVCA website, and they have resources, and you can download those resources. Those documents are excellent. They're in the sort of almost universally agreed form for a Series A financing, and it gives you a good idea as to the provisions that you would expect to see, and a shareholders agreement, especially for a shareholders agreement that you'd be getting either seed financing for or a Series A equity investment for from like institutional investors. And it's a great resource. And the investor rights agreement, right of first refusal agreement, and information rights or co-sale agreement, things like that are based on the U.S. forms from the U.S. Venture Capital Association as well. So we've talked about why enter into it. It is, as soon as you start having multiple people who have a say in the corporation, you're giving up some personal control. So as you bring in more shareholders and you issue more shares, you are essentially saying these people now have a seat at the table in terms of their ability to elect directors, in terms of their ability to approve fundamental matters or changes. And that's a great thing, because often why you're making them a shareholder is they've provided some sort of value to the corporation. If it's an investor, it's usually in the form of capital financing. So they've given the corporation money in exchange for the rights to hold shares in that corporation or some other equity security. Sometimes you'll also have like you'll have a stock option plan. And so part of the compensation you may give to to employees or contractors who are working with your corporation from an early stage or even afterwards is the right to acquire shares of the company subject to a share option plan. And all that is saying, Graham, for your time work at the corporation, giving you the options to buy 100 shares of ABC Corp. And in connection with exercising that option, I have to pay money to the corporation. Maybe it's $1 a share, maybe it's $10 a share, and then I get those shares in return. And why do you understand shareholders agreement? Because you may want to ensure that those shares are subject to the provisions of shareholder agreements regarding transferability, regarding voting rights. So you make it a condition for anyone who's going to receive shares of the corporation to become party and bound to that agreement. One of the things I think I missed, and it's absolutely critically important, if you have a shareholders agreement, on important terms you can never include in it. Right? So, I think I mentioned tag along right, but the really important one is drag along right. And all that is that you can drag the other shareholders once you have a majority, or maybe certain shareholders can, if they want to enter into a transaction to sell all of their shares of a corporation, you can require by contract all the other shareholders to sell their shares on the same terms and conditions. And why do you want this? Because Joe and Jill have invested thousands of dollars in this corporation. They've grown it, and Microsoft's on their door, offering them up $20 million to acquire their corporation. And this shareholder, Graham here at the back with 5% of the company saying, guys, I don't really want to do this deal. I think you should grow the company. I think we can get $50 million from Microsoft. Let's not do that transaction. And Microsoft says, I don't want to deal with Graham, so you got to get him out of here. You could force Graham to sell his shares. Jill and Joe could force him to if there was drag along rights in the agreement, which essentially give the shareholders, a majority of the shareholders or certain shareholders, if they're entering into or selling shares constituting a majority of the voting rights or the shares of the corporation, to drag every single other shareholder kicking and screaming along for the ride with them. And it's a really important provision having an agreement if you want to affect a sale of a corporation. They're often not used a lot because often shareholders are seen eye to eye, but the fact that they're in there, I completed a transaction last year where we relied on a drag along right to take shareholders with the majority when selling. And they're in there because it sets up the expectation up front that the majority of shareholders or certain shareholders have the right to require all the other shareholders to sell their shares in that type of transaction. Because the last thing you want to have is a wonderful opportunity to realize on your investment what you've done and to have that held up by a minority shareholder or someone who, really shouldn't have any say at the table when it comes to a material transaction such as that. So that's a key consideration for why you should also have a shareholders agreement. And I think it's imperative that, that you always have the shares subject to those drag along rights. And that's clearly defined. And, if you're concerned about it being a simple majority, it can be, you can do with contract essentially whatever you want. And this is why it's important to have good lawyers. So, Jill and Joe say, well, it simply can't just be a majority of the shares because I don't want Joe to team up. Jill says, I don't want Joe to team up, with other shareholders and force me to sell my shares. You could define it, or the drag along rights could only be triggered or effective on unanimous agreement among Joe, Jill, and any other shareholders that constitute a 50% majority of the voting shares to sell their shares. So you can do things like that to kind of protect your interest in the corporation and ensure that you have a say on any sort of material transaction. We've already addressed sort of the benefits of a shareholders agreement, but it's essentially controlling the corporation and ensuring that you can maintain management and control the corporation on a go-forward basis. It will get, if you do an equity financing round, so if you were to do a seed financing round or a Series A round, those investors are going to come in and they're going to change it. And that's part of the life cycle of an early stage company. But I think, for the most part, when you think about it from a founder's perspective or from, a really entrepreneurial perspective, you really are entering a shareholders agreement when you got more than one shareholder and you're trying to ensure that you get control of the corporation.
So I see two questions here. First one is from D, and this question is about voting and non-voting shares. Are there any differences other than being able to vote? And is there any risk with writing too many non-voting shares? Say you have 10 voting shares, but you end up writing 1 million non-voting shares to investors. Is there a risk of losing control?
Yeah, so it always have a lawyer draft share provisions and share terms, because this is what's going to give everyone their respective economic entitlements or rights, right? So, think about it as a way of carving up a pie like you got here on this slide. They could be non-voting shares, but does that entitle them to equal payment on dissolution? Does it entitle them to equal payments and proceeds of the corporation on a wind-up or liquidation event? So, for example, if you had 10 common shares that are voting and 10 non-voting common shares, unless there's you typically have provisions in there saying the entitlement is equal, or you could say there is no entitlement on the non-voting shares, or it's 1/100th of the entitlement for dividend or liquidation payment rights as on the common shares. But if you stayed silent on those things or you didn't draft them properly, one thing you could run into is the fact that you might own all the voting shares, but you have literally no economic and entitlement to the corporation. You have a fraction of 1% if you gave it 1 million non-voting shares and you had 10 voting shares. Notwithstanding the fact you can elect all the directors, you have no economic entitlement to that corporation. So there's ways to get it easily wrong. I spend, when we do more complicated transactions like Series A transactions or equity investment with seed investors, a lot of time is spent on, and it's a big legal document, 20, 30 pages long, setting out all these rights and entitlements, because that's what they're investing on. That's what the investor receiving that preferred share or the founder holding that common share, that sets out the holder of that share's rights, entitlements to receive any, to vote, to receive dividends, to receive benefits, and there can be priorities afforded to them. So you can say the preferred share gets X amount of money in priority and in preference to a regular common share, or every payment made out on Class A common shares is 2 times what's made on the B common shares, things like that. But it's really important to get that right, and it's really easy to get it wrong. And so always, consult a lawyer when you're drafting or working on any share provisions. The good news is you have to file the articles, so it's what's in the articles and it's what's there. But I'll be honest, I see, there's always nightmare stories. People come to me, they've gone shareholders agreements completely wrong. When there's dispute arise, it's really ugly because they didn't know what they're doing. Some of the provisions don't really make sense. And same thing with share rights, because that's really what is allowing you to financially benefit from the corporation at the end of the day, right? On any share sale or any liquidity asset sale transaction. So important to get those right.
And we have another question coming from John. What if your co-founder misleads you on agreed to shares and kicks you out and keeps your intellectual property?
So it's really important to document things properly when you have co-founders. So part of that is again, you can either get your own legal counsel to assist you, or you can have jointly engaged legal counsel to act for the founders. If a legal dispute were to arise amongst those founders, maybe the lawyer can't act for either of you going forward. But it's really just important to have that done. I mean, ideally what you're doing is you're taking all the intellectual property you may have personally developed prior to incorporation, and you transfer it into the corporation, and each of you are issued shares, and your rights and responsibilities and obligations, entitlements with respect to that corporation now are going to be set in all these documents we talked about. So it's going to be in the articles of the corporation as to what those shares entitle the holder of. It's going to be in the shareholders agreement. So maybe you as a founder have contributed a lot of intellectual property, but you only got 40% of the shares. How are you going to ensure that you have the right to a seat of the board, or a right to material decisions of the corporation going forward? Or your other founder doesn't just issue him or herself 50,000 options to dilute you down. Like, how are you going to deal with those issues? Like, what does that look like? So that's why it's really important, and I can't stress enough, while you may be able to do your homework and look at these documents, you really got to talk to an expert. There's reasons why there's corporate lawyers out there, and they have an expertise in these fields, and it's very complicated, very difficult stuff, especially when you're putting so much time and energy and money into these ventures. To if you get it wrong, it's bad, and it's sometimes very difficult to fix, especially when that fix requires the consent of someone else. So we do it all the time, where two founders come in or three founders come in, and one person is no longer involved in the corporation on a go-forward basis, and the other founders want to take away his or her shares, or want to feel like they've been cheated because they gave this person 30% or 25% of the equity of the corporation. Now they're not doing anything. How do you deal with that? I deal with that on a regular basis all the time. And those are conversations you should actually have up front with your lawyer and with your founders, to what it looks like if one of you leaves, or like, I'm contributing this, but how am I like we've been friends for a long time. You're not going to stab me in the back, or you're not going to give your family all these shares for like maybe very little valuation, because you control the board of directors and the corporation's got a little value. Those are all things they're real legitimate issues and concerns, and they're probably things most entrepreneurs wouldn't really even think about on this on the face of it, or at the start.
So I'm going to get to two more questions, and then I will let you continue, because we've got about a half an hour left in the workshop. So next question is from Thomas. Is there a sales threshold value that you should have to incorporate your business from a sole proprietorship or a partnership?
So I mean, you don't. I mean, if you're a sole proprietor, you can do whatever you want. And I mean, in terms of value threshold, it really depends on what you want to do. I mean, if you're thinking about like a minimum threshold value to sell your business, if that's something if you set up a corporation and you agree with the other shareholders that, look, like, if we get an offer above, take it, $5 million or whatever it is, then we get to affect a share sale or a drag along right can't be for less than $5 million, or a liquidation event like a sale of all the assets, or substantially all the assets of the corporation, or a license of all its technology can't be for less than $5 million. You can do that. I just would rather, as a not agree to thresholds up front, but rather retain the discretionary right to have my say or require my approval on those transactions as when they occur, as opposed to agree to amount up front, because things might change. Maybe you go from having a great idea to thinking, hey, we are on the verge of having a unicorn here and hitting something so far out of the park. I don't want this person selling early. And you may not be able to come. You may think about $5 million selling. I got a 50% stake in this right now. Sounds like a great idea. But if all of a sudden you take something and you work at it for another couple of years or whatever, and you now think, wow, I could, I don't need to exit at this value, or I don't want the other person being able to trip or trigger a sale at this value. You can deal with that then. So I wouldn't try to peg yourself into or pigeonhole yourself into a particular valuation or particular thing at an early stage. I try to retain as much discretionary right to authorize and approve matters as long as possible.
Okay, and last question we're going to take in this segment is coming from Will. Is there a good number of shares to issue at the start?
Yeah, that's a good question. I mean, you are essentially, you have a one pie and you can cut it up with 3 shares, like in this slide here, or you could slice it up into like 300 million shares. At the end of the day, if there's $1 million to distribute and it's going to go equally to all the shareholders, whether it's a fraction of a penny being paid out per share or it's $333,000 per share, that's just the reality. On the start, it depends on what you're gonna do. I typically, like, most early stage startup corporations, if you go the typical route, require some equity financing at some point. They often will look to get seed equity financing. If that takes the form of seed shares, that you're looking at giving up, maybe anywhere between 20 and 30%, 40% of your corporation to seed investors, right? The founders would retain the other half. Then you go and complete a Series A financing. You can always adjust it later on, but typically, I think it looks good when you're issuing shares for above $1. Again, it's more optics because you can always what's called a share consolidation or share split later, and the share split later would essentially, you'd give each shareholder for every 1 share they own, 1,000 shares. But generally speaking, when I organize early stage companies, like there to be at least 1 million shares issued and outstanding to the founder group at the time they're doing a seed round. I don't know if that helps at all.
Perfect. Yeah. So I'll let you continue with your slides, and then we'll have a next round of questions.
Yep. Talked a lot about the unanimous shareholders agreement. Finance. So like, why do we care so much about, we talked a little bit about share terms, about shareholders agreements, about all this. At some point, your corporation is going to probably need funding. Very, very rarely does a corporation, especially when it's growing, grow organically, especially if it's doing, especially if it's going the typical route where you're looking to make a large, quick impact in particular market or segment. And so when you're getting funding, I think, I'll make this brief. I could talk about this a lot. Almost 80% of what I do is always geared towards this. When I'm thinking about early stage companies, I'm setting them up to get funding, whether that's debt financing, whether that's doing a SAFE financing, which is a simple agreement for future equity, whether it's a convertible note financing, which is a debt instrument that converts into equity, or whether it's like a Series A financing or a seed financing. It's always about getting the corporation money. So when we're doing all these things, when we're incorporating the company, when we're organizing the company, when we're setting up the shareholders agreement, we're doing it so that your corporation is well organized, that you're in control, and that you can, when you go out and talk to investors, you can be, put your best foot forward so you can obtain the funding your business needs to really drive home the investment. And when investors are investing, they're investing on you as managers, as the people who founded this company and who are able to drive it forward. And it's hard to stress how important it is to have really good corporate books and records. And in addition to having a good business model and a good corporate organization, when you want to have these tough, like when you want to go and get funding. If they're doing equity investing, they're going to look at all your corporate documents. If you have like shares issued or options issued and they haven't been properly documented, that's going to be an issue for anyone when they're doing due diligence on you. When you're going out there and talking about doing convertible notes, like, do you understand is your corporation properly structured so that if and when those notes converted to equity shares, that you're going to be protected, or you're going to have the right entitlements? Like, what are these parties going to have to become parties to your shareholders agreement? What does that look like when you're negotiating it? So I think it's imperative that you kind of think about it from the perspective of, we're doing this also on the basis of ensuring that when we're doing this, when we're doing the incorporation organization, it's not just for us, it's for planning for the future and being able to put our best foot forward so that we can obtain the financing and funding that we need. It's also really important to understand that, and it might seem really superficial, the funding is going to the corporation, right? The corporation is the one issuing the shares. The corporation is the one receiving the cash, or issuing the debt instrument, whether that be a convertible note or if it's a SAFE, something like that. And it's taking the capital. And why is that important? That's important because it's not being paid out to you as a shareholder or you as an officer director. It's really being paid by investors or given to you to drive the corporation forward, so the corporation has the working capital it needs so that it can go and grow its business. Often, early stage companies, sometimes I've seen people say, well, like, do I give my shares to this investor? And the answer is no. That would be a secondary share sale. that you, I mean, that's great if you want to get the money, but almost always investors don't want to give you as a founder money. They want to give the corporation money because they want to see a return on their investment, right? And they want the corporation to be able to use that money that they've given to them so they can grow the corporation's business and operations. So I leave that there because I think it's one of the most, actually, like, when I think about all this, there's a much larger picture, and that picture is the life cycle of the corporation. And at some point in time, from an early stage company, you're going to need to go out there and get financing and funding. And a lot of what we do in terms of the corporate organization, the articles, the governance, all that stuff goes into this. And this is going to lead into the next point too. So I'm going to just run through maybe really quickly the rest of the slides and we can talk about it. Intellectual property. Every single corporation has intellectual property. Every single business has intellectual property. It doesn't need to be registered. It doesn't need to be a patent. It doesn't need to be a trademark. It doesn't need to be capable of being a patent, trademark, copyright, industrial design. Your business plan, that code you wrote for some application, an idea is intellectual property. And it's intellectual property that you maybe as a founder have, and that you need to maybe put into your corporation. So one of the documents we prepare with an incorporation is we typically get the founders to transfer and assign over to the corporation all the intellectual property that they've developed in connection with this business plan or whatever might be leading up to the time of incorporation. If you haven't done any work, you say, look, I just want to incorporate a vehicle. I got this idea, it's really not worked out. You can do that, and then just going forward, you just got to make sure that all the documents you enter into with respect to the corporation or anything else, with respect to the IP, are in the corporation's proper name. And again, this is really important because often what early stage companies have, especially in the tech world, is usually it's a lot of intellectual property. It's not a lot of physical hard assets. It's not, bricks and mortar operation and commodities and other things like that that have, real value. It's in the software that they're gonna license out or offer it up as a service, things like that. But everything you have, even if you have a business idea, you've got intellectual property. So every business has this. It doesn't need to be registerable. The one thing you should do is you should, as part of your business plan, identify your IP. And like a lot of people don't do this, but like think about, okay, like what intellectual property do I have? And if you think about the broadest possible terms, you have a lot. Like you probably have an idea of the clients you're going to target, the customer, the clients that you want, how much you're going to pay, how are they going to pay you, your costs associated with it. Who you're going to attack in the market segment, all that sort of stuff, a name even, all that's part of intellectual property. And it should go into inform part of your business plan is how you're going to develop that, how you're going to use it, how you're going to leverage it. Protecting ownership of intellectual property. Anytime you deal with an independent contractor, you deal with an employee, it's really important that you get the proper assignments so that the corporation is clearly the documented owner of the intellectual property. This is a huge issue for investors when they come and look at corporations when they're doing their due diligence, because they want to make sure that the corporation owns what it says it owns. So if you had a founder that was actively involved in, like, let's say writing some code or coming up with a business idea and concept, and that person's no longer there and you don't have the IP assignments, one of the issues investors could have would be that, how do I know that the corporation owns all this stuff this guy did before? I see his name on all these stuff. You're sharing me, files with his name on it that show that he created it or was involved in the creation of it. Like, where's the IP transfer form that says he transferred this to the corporation? And that's an issue. The other issue with ownership is making sure that the corporation on documents going forward is properly registered. So if you enter into an agreement with a software developer, the corporation is the owner of what's being developed and provided. And those are important documents. And they're important documents because it's like almost like a legal chain of custody or ownership of it. And it helps as you guys or founders and startups, when you're going out there and talking to investors or other potential people who you're looking to do business with. Confidentiality agreement, non-disclosure agreements. You can find them online. There's, usually there's actually very little negotiation from lawyers on it because it's almost agreed to forms are now, pretty ubiquitous. And one of the most important documents, why do you enter into a non-disclosure agreement? You enter into a confidential non-disclosure agreement if you want to talk to an investor, if you want to share with someone your business idea, if you want to see, how maybe you can leverage what you have with another business or another person. All these agreements do is they essentially say that what I give you, you agree as the other party or receiving party to keep confidential. So it's a way that you can actually enter into, discuss, and share what you're doing about your business and business operations, and either to attract investment or to materially take it further. If you need to, determine whether or not someone can provide you as an independent contractor with services, if they have the sufficient know-how to provide the services that you need to hire them for, and you need to sort of share information back and forth, you'd enter into a non-disclosure agreement. All that non-registered intellectual property we talked about, this is the way you protect it. So if you have trade secrets, you've got a business plan, if you've got customer lists, you protect them with non-disclosure agreements. So it's a really important document. And before really sharing any material information or the secret sauce of what your corporation is or does, I definitely would have the other party enter or sign a non-disclosure agreement in favor of the corporation. There's some asked about independent contractor versus employees. For startups, to the extent you're able, do not have employees, have people who are independent contractors. And this will often make sense because usually their commitment time-wise and stuff like that will be more in line with an independent contractor, as well as the services they're providing. You have, to the extent you're able to, the independent contractor relationship needs to be properly documented. And there's usually sometimes the courts or the tribunals will give a presumptive starting point that is actually an employee relationship. So it's important to have the agreements properly drafted to properly reflect that the people that you're working with or who are providing services to the corporation are independent contractors and not employees of the corporation. So talk about commercial contracts. Commercial contracts can be it can be an independent contractor agreement. It can be an agreement for licensing your technology. It can be any real agreement among the corporation or between the corporation and a third party. And they can take different forms. So if you're engaged in software service, you might have a standard form of software service license agreement. If you are engaged in the shipments of goods or services, you have a standard form purchase agreement or a master purchase agreement. If you are an independent contractor, you may have a form of independent contractor agreement. These commercial contracts can, they're important to get right, and they're important to get right for your business. And it's not a one size fits all. And, if you're looking for, terms of use on a website, that might be the commercial contract that your business needs. And, it should be tailored or customized to how your business operates, its business model. And it's important when you're looking at putting together these contracts, again, that I'd strongly encourage you to engage competent legal counsel to assist you, because, getting it right from the start, I think is really important in terms of making sure your business is properly protected and properly structured. So we talk about e-commerce agreements. These are some of the ones that, I act and help companies with on a daily basis. Websites, terms of use and conditions. So it depends, on the nature of the business. It could be something really simple. It is essentially saying, look, to use our application, to use this app, to use whatever, you're agreeing to be signed up to this. Very few people read these. That's an issue in itself. Notwithstanding that, the courts, I think, generally by and large, uphold and enforce them because that's necessary for the way in which we do commerce. So clip-clop end user license agreements, you buy a piece of software, things like that, you basically have to sign up to the terms and conditions. It's a condition for you to use it and install it and operate it. Software service, SaaS agreements, if your company is, if you're doing business to business for a software relation, privacy policy, depends on the type of information that clients, like a social media platform, what they're providing you with, things like that. But all of these are just like any other commercial agreement you'd enter into. If you're engaged in a reseller arrangement for online e-commerce marketplace, that might be a material agreement that you need to have signed up with all the people, all your distributors, all the people you're buying goods from. So these are just examples of e-commerce agreements. The material terms and conditions will change with each one, and to the extent that you have, or there's businesses that are currently operating in the space that that you want or your startups operate in, look at what they're doing. Is usually a really good starting point, and it may even help you just looking at those type of agreements that you can find online, through downloading their software or through trying to use their website or their application, as to what maybe things you should be thinking about. I wouldn't say take them on face value, but it certainly might be a starting point for you to use or work with your lawyer and customize and preparing your material agreements. The bottom line for commercial contracts is that you need to make them work for your business, and that requires customization. So one of the reasons why you have lawyers here is so that they can think about what you're doing, how it might be different, and how to incorporate the right terms and conditions to make sure that you're protecting your business protected. so that you're capturing, all the key things that you need to capture, whether that's even simple, just payment terms, timing for it, transferring of title on properties, things like this, no rights to use the intellectual property, what happens if someone breaks, the terms and conditions on your website, do you have the right to kick them off, all that sort of stuff, right? So there's all sorts of things on there that you need to be thinking about, but they're always business specific, and the best way to do that is to have someone who's competent help you sort of navigate those different problems and formulate solutions that work for you and work for your business. So I think we have 10 minutes left, so I'm happy to talk about any of the topics or any other topics you guys want, answer any questions, or just have even general discussion about things.
Perfect. So I do see some questions in the chat that we can get to. First one is from Linda. Do you advise to using a bundle online packages for startups, especially when it is only one shareholder at first, to save the lawyer fees, aside from shareholders agreements that are more complex?
Yeah, there's great online like legal tech innovative companies who are offering incorporation packages. If what you're looking for is simply to have the protection afforded to you by limited liability corporation, I think that's a great option and makes a lot of sense. As soon as you've got more than one shareholder, I think there's ways to get that. I think it's best to talk to a lawyer and understand issues, especially a lawyer who's familiar with startup companies and early stage companies and what can happen, and to have that structured a little differently. But by all means, there's a lot of online platforms, applications that allow you to incorporate, and I think that's okay for an early stage company, especially if you're like a sole founder.
Okay, perfect. And next question is from Sue. Sue is thinking of going after a B Corp incorporation, and she's asking if she would do that instead of, or in addition to, a federal incorporation.
I'm just sorry, I'm probably difficult to get an exchange. I don't really know what you mean by B Corp. I don't know if like a C Corp might be like I think a US sort of tax status with respect to corporation. I don't know if there's anything different there. A federal corporation in Canada is it's completely fine. It is easy to do online. You can do searches online to find out the business name. Both are federal corporation versus provincial corporation. I said I think the trend now is to incorporate federally in Canada.
Okay, perfect. And then another question is coming from Keisha. How do you register intellectual property, and do you need a lawyer for that?
So one, the property, the intellectual registering has to be capable of being registered, and that's an issue. So you have to have something that's that can be subject to trademark registration or trademark protection or copyright protection, or to be a patent. And there's various legal tests you have to do to sort of satisfy, especially the patent issue. Copyright you can do online. It's getting a little more challenging with the way they've structured the system, especially for trademark registration right now. You can do it online. It costs about $2,500 for the whole process to have a lawyer assist you with a trademark application. And that, right now the Canadian Intellectual Property Office is a little backed up in terms of processing applications, but it's I think it's best to go through a lawyer so you get done right the first time. And you can do searches. So I encourage, if you are looking at registering a particular piece of intellectual property, the Canadian Intellectual Property Office has got some great resources. And I know less. I've go online to the USPTO or United States Patent and Trademark Office as well. But just do a Google search and check out the Canadian Intellectual Property Office. Fantastic resources on there, can really help you navigate. You can do searches yourself to see if someone's using a similar trade name, or has what's been registered and filed in that area. And even if you know that you're in a beverage producing business and you want to see what Coca-Cola's done, just go search who, like, Coca-Cola as owner or a Coca-Cola company or whatever it is, and you can see all sorts of different, all the intellectual property that's been registered by Coca-Cola or owned by it. So there's things you can do there, but it's tough. Like, so, if you're writing computer code, like that, while it might be able to be subject to copyright, you might not want to do it. And there's legal reasons for that. Doesn't give you much, copyright doesn't really give you much protection or afford many rights when it comes to code, or it can be simply changed or modified. So there's things like that that you have to sort of think about.
The next question is coming from Dee. What is your take in setting up a corporation as an investment vehicle for example, holding companies? And what kind of advice do you have for writing a shareholders agreement and how to structure the shares if investing with a co-founder?
So I'll answer one. You can definitely use a corporation to hold shares or property. There's tax reasons for that. It's difficult to give particular advice. There might be reasons why you don't want to do that, and that has to do with whether or not you can benefit from a Canadian lifetime capital gains exemption on disposition of shares, but that's like a whole nother issue. So to the extent that it depends on what you're investing in as to whether or not you want to use it, and how you want to structure a holding corporation, but they do have a function and they do have a purpose, and you can definitely do it. And with respect to share classes can be used in all sorts of different ways. Some people will contribute assets, some people might contribute shares to a corporation. My preference for early stage companies is to have one class of voting shares, and then to structure the rights and privileges with respect to different shareholders in a shareholders agreement, as opposed to having different classes of shares doing things like this. When you bring in external or third party investors, it becomes sometimes unwieldy or overly cumbersome and difficult to deal with multiple classes of shares among founders as well. You got a lot of drafting issues around ensuring that the articles properly reflect sort of the economic entitlements and what happens and things like this. And it makes sense if you're looking to get, there's like tax considerations that go into these things. And some of those tax considerations is you may not want to increase the someone's capital contribution for tax purposes on a particular class of shares. But very often that's not the case, especially because they're coming at the same time. But again, those are issues that you really want to address with a lawyer. And again, there might be a reason why if I'm coming in with $100,000 and you're coming in with your time and energy, and we're both starting up a company, I want a different class of shares than you, because I don't want to write off 50% of my, assuming we're 50-50 shareholders, 50% of that that capital gains sort of treatment there, or give it to you as basically free capital, so or free tax treatment. So there's issues there, but they're very complicated, and you should seek legal representation and helping you sort of navigate those issues.
And I do see another question from Keisha. I think this was in regards to your previous question about the intellectual property, and she's asking about what about something like a slogan?
Yeah, so a slogan, it might be subject to trademark. So, you can go in there and look at it, but you could possibly trademark that slogan as a trademark word, or if you have a particular way you've designed it with a design feature as well, you can trademark that too. But you have to look at that and see how much you can definitely trademark slogans, intellectual property offices, resources, the online resources, things like that. And then I would even say talk to a lawyer and see, even just say, look, I'm thinking about doing this. Is this something that you can assist with? They may not be able to tell you whether or not it's trademarkable, but they may be able on especially if it's an intellectual property specialist, give you a good sense as, no, that's not, yes, it is. We'd have to do a search, but on the face of it, it's not confusing, it's not similar to things, it's not offensive, things like that. So
is there a proper way to go through to make photos and music part of your IP?
There's no real proper way. I wouldn't take things online. People may have residual rights in those the stock images you see online. So to the extent that you create them yourself or take them, that's the best way to do it. Or you pay someone who has legal ownership in them to use them, and you make sure it's properly documented. That's probably the best way.
Next question is coming from Paul. He was wondering why you recommend contract versus employee when starting with staff.
Mainly because your obligations for termination, severance pay are there's none under independent, like there's none with an independent contractor. You also don't have to go through the issue of minimum wage or through a bunch of the other sort of statutory requirements when it comes to setting up and remitting sort of payments for Canadian pension plan, other things like that. So from an administrative perspective, I think it's a lot easier. It's also easier for an early stage company to limit their exposure and obligations with respect to people, like especially now and most businesses, a lot of work's being conducted on the internet or ways you're having people provide you with certain services at the early stage time or early stage of a company that, an independent contractor can provide, and you don't need to, have a part-time employee doing it. I mean, if you need to have someone, a physical presence in a building, we're saying, as an assistant, or providing certain services like, a manning, or a cashier, like that's different. Like you may not be able to get around it. They're just an employee, period. But to the extent that you can structure it, there's all sorts of better things too in terms of like taxation for the most part. You get to write off all sorts of costs. Like I would personally look to have them provide their own equipment, right? As an independent contractor, they got to provide their own laptop if that's something you need them to do. So it can cut down on your expenses on an upfront basis and really protect you in the long run in terms of the corporation's liability or exposure.
And I see 2 more questions in the chat, so we'll take the 2 and then we'll wrap up. So the next one is from Muna. Do you recommend trademarking your logo in the US as well as your product name?
Yeah, so that's a good question. Absolutely. I mean, where are you going to operate? So you can get so one thing that's really interesting and great is if you register a trademark in Canada, you still have 6 months. You can, within 6 months after filing that trademark, go and file in the United States with a retroactive filing date being the date you filed in Canada. I mean, look, Canada's a great market. It's a fraction of the United States, like 1/10, right? And a lot of time that if you're really looking to grow your business, you're going to look to take it stateside at some point. And with that, you don't want to have at the start got goodwill, got good traction with a name they've trademarked or they can use in Canada, and then only find out later on that you can't use it stateside or there's some other person doing it. So part of your business plan would be to like look at and talk about the long-term, your long-term IP and like its use and how you can leverage it. Would be like, okay, what happens if I go stateside? Can I use this here? If you think it's, you got something really special, you can file here. You can also file stateside. And do it that way. And it's a great, especially if you have the resources available up front, and you're going to stick with that sort of that name or slogan. So I mean, definitely encourage you. And also, registering intellectual property, especially trademarks, helps. It's a registered piece of property. It's real property you own, and that it helps to, when you're talking to secure investors or talking to license anything out, it's something that you clearly have your corporation has a lot of rights in, and it just makes everything, I think, a lot easier to engage in this type of commercial transactions. And you can leverage it too. Like you can license it, assign it, grant someone security interest in it, do all sorts of things like that. There's also unique things about trademarks. It gives you a positive, in Canada at least, I can't speak for the States. If you're granted a trademark, you have a right, a positive right to use that slogan or that trademark in Canada and every single province and territory with the goods and services that is registered with. So you got Coca-Cola, like registered beverages, you get the right as Coke to like walk into any other province and territory and use that name with that product. So if you're going direct to consumer, especially, and you think there's goodwill associated with that product, it might make a lot of sense once you start getting traction to register it. I mean, I think that's general advice. You don't need to have a huge portfolio of trademarks or anything like that. But if you have the resources available and you've starting to get good traction or utilizing a name or trademark, definitely think about registering it, especially if you're going direct to consumer.
And we have one other question from Jess. Do you have any thoughts regarding web scraping, and is it legal?
I'm not really familiar with what web scraping means. So I mean, unfortunately,
So I think
I can't.
extracting data from websites, if I'm not mistaken. Jess, feel free to unmute your mic and clarify.
I don't know anything about that subject matter. I would suspect that you might be in breach of the terms and conditions for using that website or information posted on it. And so you have to be careful about that. And I don't know what you'd use the website scraping. You might be fine what you'd use that for if you're going to, do some data synthesis or automatize or sort of that information. If you're picking up, private, I don't think you'd be picking up privacy information, but, if you're doing something or affecting someone else's software or code or doing anything with it, it might be an issue. If you're not, and it's publicly available information and you simply have a good algorithm to, work through and take out what you deem to be pertinent information, that might be entirely legitimate and completely fine. It's just a general question. And sorry, I'm not able to provide a better response.
That's okay. I think that answered the question. And I see one last question, so I will take that one. I know we're a little bit over time, but the last question is from Ethan. Can founders pay themselves as contractors?
So there's issues with that. You can pay yourself as an independent contractor. This is really a tax accounting question. There's the CRA in Canada at least may take a different approach. If you are, first of all, if you're the chief executive officer president, there's a default position is you cannot be an independent contractor for the corporation. If you are providing other services, there's a long sort of test that needs to be looked at, including whether or not you're supplying your own materials, like you bring your own computer, you're not using the computer owned by the corporation. If you're providing your services to more than one client or customer. So, if you have other jobs or you're also, freelancing, whatever coding services to another, other non-competitors maybe, or something like that, that might be more indicative of you actually having a true independent contractor relationship. The corporation can pay yourself like a wage and a salary or all that stuff, as and when you have money, but you really need to sort of think about, how you're taking money out of the corporation when it's set up, and whether that, and part of that might make sense to be, from a tax perspective, to pay you a salary like as an employee.
Okay, perfect. And I see that we're now at 8:06, so I do want to close off now. But Graham, I do want to thank you so much for dedicating your time to us tonight. I know there were lots and lots of questions, so thank you so much for answering all of them. And really, really thank you for dedicating your time to creating the presentation, and again, and working with us again with the Founder Fundamentals series. So thank you.
Thanks for having me.
And I do want to extend thank you to everyone who joined us today for this session of Founder Fundamentals. Again, we will be sharing the recording of the series once it is ready. And we will be sharing Graham's presentation as well. If you didn't receive it, I will email it out to everyone. Just to let you know, we do have a few more sessions coming up. So the next session that we have actually is next week. So next week is all about setting up a Shopify store. So that's on November 12th. And then we have social media strategies, followed by best practices in sales. And then we close off in December with pitching and storytelling. So again, if you did take 9 sessions out of the 11, at least 9, you will be getting an Innovation New York Certificate of Recognition, which will be emailed out to you at the end of our last session in December. Just a reminder, if you do want to register for any LaunchU events, please do visit our website, launchu.ca/events. And I will be sending out the survey link. I shared it in the chat, but if you can take 1 minute to complete that and let us know how we did today and how we can improve for the next session, that would be great. Thank you, everyone. Thank you for joining us, and hope to see you again next week. Bye.